Welcome to Unwritten Law. This is John Vecchione. I'm here with Mark Chenoweth, as usual. And like the post office, neither sleet nor snow nor ice or driving rain will stop us from producing Unwritten Law. So in any event, I hope you've all dug out or are digging out well from the snowstorm. But we have some very good news to report. We filed our brief before the First Circuit trying to overturn the district court that found that fishermen had to pay for the monitors that the government puts on their boats without any statutory authority. So we appealed that case, that ruling, and I think we've discussed that before, but we have now received the magnificent seven, I want to say, Mark, Amicus briefs. And all
we weren't the only ones outraged by the district court's
We were not the only ones
decision.
outraged, and some of them are old friends of ours, some of them, but all of them did an absolutely good job, because when I was reading them, except for, Chevron is overruled, there wasn't a lot of repetition. The arguments are all slightly different and all really interesting. And in fact, even though I've been doing this for years, I learned a number of things that I did not know or had not seen put so starkly before. And that doesn't always happen once you're really used to something,
Sure.
right? So I'd like to go through it and give a shout-out to each group that put one in. And I'll give pride of place to Americans for Prosperity and Ryan Mulvey, who obviously was also the counsel on Loper Bright as cause of action. And
they know a little bit about this.
They know
topic.
a little bit about this, yes. And so this case was this amicus brief was very clear on some post-Loper decisions, like McKesson and the county case that came out, where the Supreme Court has reinforced Loper Bright and reinforced the idea that the courts, first thing they should do is decide the bounds of what Congress allowed the agency to do
as a matter of statutory interpretation.
As a matter of statutory interpretation. So, and it also pounded very hard on that it should be de novo review, and each of the four things the Supreme Court has said to look over, they've got to look over and use canons and things like that. But then the really important part of this brief that I think was more stark than in many of the others was that you can't use necessary and appropriate to do anything you want. And so they argue very strongly that this rule by the agencies to have the fishermen pay for their monitors is neither necessary nor appropriate, because there's appropriations by Congress, because the fact is they haven't done any there's no delta. There's no delta between what the paid-for monitors and the unpaid-for monitors are going to do. So it was very stark and clear what the Supreme Court has done since Loper Bright, and that none of it was addressed by this district court, and none of it was followed by this district court.
Who's next?
Next is Buckeye. Our friend David Tryon said that this will cause constitutional confusion. And and he has three arguments, one of which we actually had in the Gaithel case, but we removed. And I haven't seen it in a while, but I enjoyed how he did it. And that is, first, all bills for raising revenue shall originate in the House. That's appropriations. That argument's been made. But he put very stark.
And these appropriations originated in the executive branch.
In the executive branch, and actually in the and in National Marine Fisheries and NOAA, they just made it up. I don't even think it wasn't like the president said, go do this, right?
Well, is the argument that there was an underlying organic statute that originated in the Senate instead of the House? Is that part of the argument here?
No. But the fact is there's no money. The House didn't do anything to raise money except, of course, appropriate for observers, right?
Correct.
So then he has one that we always liked, but we felt was perhaps a stretch, but that's what amicus briefs are for, and that is the Third Amendment. And the Third Amendment says no quartering of troops in your house. But what this brief does is note that because our fishermen are out there for 2 to 3 weeks, this is their home.
Right.
They're not out there just for a little few days.
Yeah.
They're out there for weeks. And that raises two things. That he points out that the quartering of troops wasn't the only thing. They didn't want any government officers there. And he cites where the colonists put that in. Even though the Constitution says quartering troops, it meant federal officers. And that was an interesting argument.
You can't just call them National Guard and then
correct.
Then you can have them in there.
Exactly. Okay. And then he said, and obviously in the home, the Fourth Amendment violations are also heightened. Because it's a more protected area than outside or anywhere else, and it should be looked at like that. So those were novel arguments, but I think they also showed that there should be more protection in this area. Now, Cato is the next one, and
you got the real ABCs of amicus briefs.
I did. And Cato put in Thomas Berry and Mr. Cavendon, who I mentioned because I do not recall seeing him on Cato briefs. I apologize, but he has a very pithy statement that I wish I had thought of to oppose this. He says, you bear your own compliance costs, not the government's from regulations. And this is the government's compliance cost because they're doing government jobs. Right. And I think that really, really isolates what the stolen bases are of this default norm. So which we'll talk about.
Got to use your scare quotes.
Exactly.
Default norm, like Chief Justice Roberts said.
And you'll they cite Chenoweth and Samp in the Wallison and You book.
Is there a better place to cite? I mean,
no, certainly not. So Mark Chenoweth and Rich Samp are in a administrative state book by Wallison and You, and they cite it prominently. And then they do something that I haven't seen in a brief, which I really enjoyed, which is they gather together all the Supreme Court cases that require clear statements for doing things. And they say that this is easily in that area where even if Congress wanted to, they could do it clearly. They've done it before. But look at all the things the Supreme Court, and they lay out like 12 or 15 of them, and quite a number of clear statement rules. And I thought it was very effective because I hadn't seen it before.
In other words,
I understand Mr. Cavendon is responsible for that.
Oh, okay, terrific. Well, thank you for that. So in other words, this is clear statement rule territory. This isn't default norm territory.
Correct.
Is that the idea?
Correct.
Yeah. Okay.
Then Landmark Legal put in a brief, and they're the only ones who tackled the major questions doctrine.
Okay.
And you think so? The major questions, and the way they get to the major question, because you think, oh well, fishing maybe that it doesn't, but they said because inspection regimes are so common, this cost shifting becomes a major question because it's going to permeate the entire federal government.
So if they're right about
it's not a one-off.
If they're right about this default norm,
correct,
then that's a major question.
Right. You can't isolate it. It's going to cover a lot more than just this case. I thought that was a very good argument, and I thought they were dead on. And again, this is an idea that was not in our brief or in any other. Well, we did say that only this case ever does this, and it shouldn't spread to others. But what he's saying is if it spreads to others, it's a major question, right? Which is obviously true, I think.
Yeah. Well, and if it's a default norm, he's already claiming it.
Right, exactly.
He's saying that he's not saying it's a default norm for this case. Yeah. The judge is saying it's a default norm for all the cases, and this is just a specific application of it. So it's a major norm. I mean, it's a major question without any spreading yet, the way he's used it. The judge has used it.
And he cites provisions of the FAA and the NRC. The FAA, for these inspectors, uses appropriations, and the NRC uses fees from industry that are statutorily identified by Congress. And he says, well, look, no one, and then he says, a thorough review by Landmark Legal could not find one place besides here and Gaethel where any monitors were funded in this manner. Yeah. I mean, that is powerful, I think. I agree with it, but I like to see, because you always think you might be missing something, and all these people looked for the things I was looking for and did not find it. So I was very pleased. AAF and Friends, they put in a lot. There were a lot of people. I can't mention them all. They have like 21 different groups.
But this is Mike Pence's group, and Mark Wheat is the general counsel
and Mark
over there.
Wheat signed it, correct. And it's a real originalist brief. It brings out the Madisonian and Coolidge statements of what the government should be doing, and that things that taking money, fees, taxes, or any other type of exaction from the people cannot just be done willy-nilly, and that the Constitution is really set up not to allow that. and it goes through. It's very originalist. I think there's they cite Ogden. They cite very old cases or the founders themselves, and then the second part compares it to Woodrow Wilson and the administrative progressives and how they're at war with this idea. And because they're at war with this idea, they shouldn't be. A court that's textualist and originalist should not be going in that direction.
This gets back to our R.J. Pestritto article that we had on the podcast a couple episodes back.
Correct. And it also hits very hard on no general powers in the Constitution. It's enumerated powers. And the Congress does have enumerated powers in this area, but nobody else does anywhere in the Constitution.
Well, and there's no general federal police power.
Correct.
So they can't just go inspect fish because there's a general federal police power.
Correct.
They have to have statutory authority to do it.
And that's what they say.
Yeah.
Exactly. And then the NFIB, the Small Business Legal Center, and the Manhattan Institute all joined in a brief by our friends Joel Nolet at Wiley Rhine and Ilya. And Trevor Burrus is back. He used to be at Cato. He's now at the Manhattan Institute. I'm always glad to see him on a brief. He's very good at this. And this brief really shows that the district court absolutely discarded Loper Bright by not doing a thorough de novo review and relying on all cases that were previous deference cases. And the fact that he didn't use any canons, he didn't use anything except to rely on previous cases that had been either overruled or vacated.
And we're seeing this not just in your case, John. We're seeing this across the board. We're seeing judges rely on old precedent that was Chevron precedent and then saying, well, I'm not relying on Chevron. Yes, you are.
Yes,
you can't rely on old circuit precedent that was based on Chevron in order to avoid doing post-Loper Bright statutory analysis. That is not allowed.
Particularly when
judges.
The case you're in was absolutely vacated, so there was nothing left of it. And not only the Supreme Court vacated, the First Circuit, when they sent it to him, said it's overruled and vacated. The First Circuit put it in their own order. So it's not like they were silent about it. Right. So and they said his cursor.
This isn't like citing an unpublished opinion. This is citing a vacated opinion, which is not something one can treat as precedent.
Right. So they said that he did cursory statutory analysis and poisoned the analysis by using all of these vacated cases. And poison was a nice word, I thought. And then they did something that I thought was clever.
And poisoned is a nice word because it's hard to disaggregate. Once a judge is using this flawed methodology, it's hard to disaggregate the methodology from the result, because how can you say the result is fine when you've used this troubling method to get there?
Right. And then they talk about the cursory statutory analysis he did. It was basically 7 paragraphs. And they compared it to Corner Post on remand. If you remember, Corner Post is the one that said that basically the statute of limitation begins anew every time you're injured by a regulation, even if the statute has passed.
Well, if you weren't around.
If your
entity didn't exist,
right,
and didn't have an earlier chance to
oppose
it. Yeah.
So then, because this was reopened, this judge did a very strong de novo statutory analysis of whether it was allowed or not.
This is the district judge in North Dakota. Or South Dakota, whichever it was. One of the Dakotas.
Maybe Nevada. Maybe Dakotas.
No, it was definitely
one. It was Dakotas, of course, banking. So anyway, and they point out that these two analyses, if you put them side by side, they're night and day. There were 41 substantive paragraphs in the Corner Post going through every single part of the statute, every part of the language, every part of the whole, all the canons, everything to come out with this. So they compare this and say, look, the district court judge has to be overruled just for not using every tool at his disposal. And near and dear to my heart, Westlaw says nobody has cited a default norm except the relentless court ever.
Meaning the Gaithel default norm.
Correct.
That this judge was citing himself.
That Chioda cited back 8 years ago.
No one else picked up on it.
No one else has said, and they said if there was a default norm, wouldn't you think someone else would know about it?
It's a very subtle default norm,
subtle.
very secret.
Subtle. Yes, exactly. Almost secret default norm.
That's right. That's right. Almost cult-like.
And then finally, the Chamber of Commerce, Chris Walker wrote it for them over at Michigan. He says this is like almost an anti-Loper analysis. He didn't fix the boundary of authorities, which he should have done first, the district court. And it just simply didn't happen. He fixed no boundaries of what they're allowed to do and not to do.
Well, and the significance of this one to me is Chris Walker was no friend of Loper Bright on
Correct.
the front end, and
Correct.
so the fact that he on the back end is looking at this saying, this isn't what the court told you to do.
Right. He was more friendly to Chevron than many of our people in this area. Correct.
Absolutely.
And he says that the substantive law doesn't allow this, and then the catch-all does not do it. And this is in the necessary and appropriate area. He says, but a catch-all can't do something this big unless you've got something else there, and there's nothing there. And then he drops the hammer. He says the default norm is Chevron by other means. And the Supreme Court did not put in Loper Bright to allow substitutions of default norms. And I think that hits it hard. And I think they also, in the chamber brief, they cite something I've never seen, which is there's a federal listing of two things that we're going to be using again and again, I think. First, it's every agency that uses ALJs, and then the other one, everyone with an inspection regime and what they do to fund them, like where do the inspection regimes come from. And so they cite, and they say there's nothing like this except here. So I thought that was very powerful. So we got 7 amicus briefs before the First Circuit. All of them followed the rule that they don't do all the same thing, and as I've laid out here, they did all kinds of different things, but all of it leads to one idea. The district court waited a while, came out with a very short analysis, which didn't do everything you're supposed to do after Loper Bright, and we know that now because, number one, the 4 things that the Supreme Court said you did not do. We didn't cabin their what was Congress doing? He didn't really look at the language compared to other language. He didn't even dispute either the legislative history that we put there, and he didn't dispute the canons, that saying one thing excludes the other thing. None of it. So I thought this was all to the good. They all put in reasons why the First Circuit should really take a hard look at this and not rubber stamp it. So I thank all of our amici in this case. I think everyone did just an absolutely fabulous job.
So this leaves me with 2 questions, John. Yeah. The first one is, well, maybe a comment and a question. The comment is, the First Circuit has everything in front of it now that it needs in order to reach the right result here. Yes. There's no doubt that with this sort of thorough treatment, there's nothing about this that hasn't been thoroughly examined. The court doesn't have a lot to work. I mean, they can pick and choose what it thinks is the most persuasive, but it has all the ingredients here to get this correct. My question is, why is the Trump administration still fighting this? I mean, these are all the same people who were on this question before.
Yeah, they all said we put in amicus briefs in Loper Bright and Relentless, they all said that.
I mean, this isn't new. The Trump administration has been vocally supportive of taking out Chevron.
Put it in EOs.
And yet, the rank and file at DOJ is still fighting this case. I don't understand it. It's completely inexplicable to me.
Well, not the rank and file. I mean, Schumatt's on these briefs. So
yeah, that's pretty high rank.
And I'm pretty sure Dan Helanen has been speaking to his higher-ups. I've talked to Dan. I do not think Dan is off on a rogue operation. Okay, I will say that about him. So.
Well, it just makes it all the more inexplicable. I mean, this should be an easy case for this administration.
Should I tell you what I think's been going on? And this is all right. Here is complete speculation.
Do we get a complete speculation?
Exactly. You can put Aaron can later on put a little sign flashing. Up. Exactly. Complete speculation. What I've seen is that the administration wants to win on whether courts are going to do things or are they going to be allowed to fix it themselves in the sweet by and by. So it's basically an only I can fix it idea from the administration, whereby they do not want to be beholden to court orders, but then they'll take it back and say the regulation will be really light. But for our clients and for the whole world, the whole thing about presidents is they don't last forever. And
look, I'd much rather have a decision from the First Circuit that gets the right answer here.
Correct. And I think everyone would. And that's the beauty of precedent is other courts are going to follow it. They're not necessarily going to follow an EO. They're not especially a withdrawn EO. They're not going to. That is not what they consider real authority. It's very minor authority to them. So, but another court, particularly the First Circuit, and this is it. If a win in the First Circuit because it really loved Chevron, it is a very pro-administrative law, Wilsonian type court, and the fact is that if they rule against this and say why, it's going to have a powerful effect on other circuits. So I do want that better than just the agency saying, oh, well, we won't do it anymore. And they're not saying that. The other thing is Loper Bright has stayed, right? They're negotiating with Loper Bright probably because of the name. Who knows why? But they're stayed, and supposedly they're doing something. But I haven't seen anything. So that's the raw speculation portion of our show.
Well, maybe I should be happy they keep fighting because we'll get this, this First Circuit decision.
That's true. We got
for the sake of our clients,
something to do.
I would like to see this go away.
Correct. All right. Well, thank you very much. Again, thank you for our amici, and we'll see you next time on Unwritten Law.
As we like to say here at NCLA, let judges judge, let legislators legislate, and stop bureaucrats from doing either.